Good evening, ladies and gentlemen. Welcome to the November 18th, 2015 ZBA meeting. The next meeting will be held on December 30th, 2015. Going to ask that we all rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For everyone that's going to be testifying tonight, can you please stay standing and raise your right hand? If you're going to speak tonight at all, you need to stand up, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Rich, could you read the preamble?
Good evening, ladies and gentlemen. We will proceed with the petitions in the order they are listed on the agenda unless the board deems it appropriate to take a petition out of order. State law and local ordinances set out the criteria that must be met in order for this board to grant a request. The minimum requirements are outlined in the form provided by the Community Development Office, and the petitioner should proceed with this format to provide adequate justification for the board to grant the request. The chair will open the meeting to hear testimony either for or against the request. All discussions will be between the speaker and the board. Please be respectful of all, and in the interest of time, refrain from repeating previous testimony. No new documentation will be accepted by the board for consideration this evening, but the board reserves the right to ask for additional testimony at any time. After hearing the facts from all parties regarding a petition, the chairman will close the public hearing, and the board will deliberate and vote on the request before moving to the next petition. Please turn off all cell phones.
Okay, thank you very much, Rich. Okay, we have a full board this evening. So when you come down, there's a clipboard with a pen. Please make sure you sign in. The mic's in front of you. Make sure the little green light is lit up. We need to have everything on record. So let me just get myself organized here. The first petition is Morgan Hollis and Gottsman and Hollis on behalf of Ralph and Jean Reed and Sunrise Homes LLC owners, request for rehearing regarding case number 2015-35, in which the board voted to deny a variance under section 3.02 of the zoning ordinance to permit a subdivision of one lot into two lots with less than required minimum lot areas, 70,385 and 43,575 square feet, whereas 100 square feet is required. The frontage would be 150 feet and 133.03, whereas 250 feet is required. The parcel is located at 50 Wilson Hill Road in the R1 Residential and Aquifer Conservation Districts, Tax Map 4B, Lot 105, case number 2015-40. This is a rehearing. This will be a discussion with the board, and we'll start with, obviously, Lenny, having reviewed that. What are your thoughts? Okay, Rich?
Do we have any new information that was presented to us?
It's outlined in the packet that we received, and the request for rehearing on the grounds, and it is listed in extent to what their concerns are, and you can read through. I'm hoping you've read through those.
Yes, but this looks like what a rehash of the evening, not new information.
Actually, if you look at it, they talk about it. They do outline a couple of areas. Court case, one particular court case is outlined in there. Chester Rod and Gun Club versus the town of Chester. There's also, they talk about the spirit of the ordinance, and they talk about. They also mention another case as well against the town of Chester.
Okay. I have nothing then.
Questions, comments, concerns, thoughts? Fran?
Is the petitioners added anything or brought anything new into community development reference? the denial.
What you have in your packet is what we have for new information.
Thank you.
So, in looking at this myself, I'm sorry, go ahead.
There's one significant piece of information that was provided in the packet that I didn't see before, and that's the letter from the Realtor.
Right, because,
One of the biggest things that we denied it on was the impact on surrounding properties. And, in fact, we used the word could, which I think is very interesting piece there. But the
Right.
fact that we didn't have this information before, and had we had it, I think we would have, or at least I would have voted a different way. I think
Okay.
the letter from the attorney outlining the reasons for this hearing is very compelling, and I think should be seriously considered.
I would agree with you on the letter from that was in there that wasn't there before. I think obviously, information like that can't be taken in at a meeting, so it's why we didn't have that letter in our decision-making process, because it has to be submitted beforehand. Regarding some of the stuff that the attorney brings out, I think some of it's a little bit of a stretch, especially if you're citing a case about a gun club in the town of Chester, and contrary to public interest, you can't really, dividing a property and putting a gun club is, that's a little bit of a stretch if you ask me. Dividing a property and a gun club are two totally different things when it comes to public interest. But I know, I understand what you're saying regarding the letter, so that's a good thought. Rich, did you have anything? Okay. Tony?
I read the letter that Lynn said, the Realtor, and I would have changed my mind a little bit more. I would have had a different view on it. That's about it. And about the gun club, I agree with you. Oh. I apologize and have my, thank you. As I said, if I would have saw the letter from the Realtor, and that's one of the things that we said no to because of the value of the property, I would have maybe voted a different way. And about the gun club, I agree with you on that factor.
Okay.
Thank you.
Fran?
I agree, but if I had had more than one letter from one Realtor, I might have looked at it differently, but we only have one letter from the Realtor. I would have liked to have had more of a cross-section of Realtors that, say, agreed on everything other than just one.
I agree. All right, I agree with you on that as well.
Or even like an assessor as opposed to a realtor.
Exactly.
But, you've got
You got to
one
make a
of- one
decision on what you
opinion.
have at the time. And that's, but I understand what you're saying, yeah.
Yeah.
Something that would be a little more tax assessment or something like that, so. That being said, is there any other further questions or comments the board would like to make before we get a motion on granting or denying the rehearing? Okay. Well, with that being said, is there a motion to grant or deny the rehearing?
I'll make a motion that we grant the request for the rehearing regarding case 2015-35.
Second. Oh. Second.
Tony seconds. Okay, all in favor, raise your hand, say aye.
Aye.
All opposed? Abstain? Okay, it's 2 against, and 2 for, so, oh no, sorry, 3 against, 2 for,
Yeah. 230.
2-3-0. So we need we need to put a motion in to deny then. Can you put that in, please? Or,
You want-
okay, Rich, can you put that in, please? Thank you.
I'm going to make the motion to deny Morgan Hollis of Gottsman and Hollis on behalf of Ralph and Jean Reed and Sunrise Homes LLC. The request for a rehearing regarding case 2015-35, in which the board voted to deny a variance under section 3.02 of the zoning ordinance to permit a subdivision of one lot into 2 lots with less than the required minimum lot areas, which is 70,385 and 43,571 square feet, whereas 100,000 is required, and frontages of 150 feet and 133.03 feet, whereas 250 is required. The parcel is located at 50 Wilson Hill Road in the R1 Residential and Aquifer Conservation Districts, Tax Map 4B, Lot 105, case number 2015-40. And the reason that I make this motion is because I believe that we still haven't met the reason that we denied it in the first place, the reasons that we had stated. And again, the information that's been provided, it seems loosely at best connected to what we're looking at.
All right, I'll second that. All in favor of denying the rehearing, say aye.
Aye.
All opposed? Okay. 3-2. All right, next up, 53 Pearson Street, Realty Trust, Joshua Naughton trustee, petitioner owner, variance under section 2.02.7A4 of the zoning ordinance to permit a residential dwelling to be constructed at 36.3 feet from a wetland, whereas 40 feet is required. The parcel is located at 53 Pearson Road in the R Residential District, Tax Map 7D, Lot 011-01, case number 2015-41. Is anybody here from 53 Pearson? Please come on down. Make sure your light's on and you sign in, please.
It's a bright,
Okay.
bright.
Yep. Jeff Bird, excuse me, RJB Engineering.
Okay. If you could give me if you could just give us a kind of a quick 5-minute, 100 words or less, why you're here, and then
Okay.
get into the 5 points. That would be great.
Okay. This is actually a variance for an encroachment into a wetland setback. We're looking to go 3.7 feet into a 40-foot setback. This variance was previously granted. This is an unfortunate circumstance where the variance was actually granted in 2013 by the prior owner. My client made an offer on the property back in June, was aware that there was a variance for this, didn't close on it until August, and it expired. The variance expired in August. He didn't get his building permit application in until September, and that's when he learned that the variance had expired. Mm-hmm. So basically, we're here to request the same exact variance I was granted back in 2013. That was, again, it was an oversight by the builder. There's, it's a pretty minor impact into the wetland buffer, and basically I went through the old variance, and it was put together by Greg Michael.
Yep.
Greg Michael, actually, I think he was one of the owners of the property, or his brother was, his family was. I'm not sure, there was some relation there, but he wrote up a good argument for the case, and I basically plagiarized most of that, to be honest with you, and I thought that he had all of his I's dotted and T's crossed, so the points of argument, if you want me to read those.
Yep, if you could read, we had to have them read into record.
Okay.
So if you could read them, just stop after each one. We may have questions for you,
Okay,
and then just go from there.
all right.
Thank you.
So number one, granting the variance would not be contrary to the public interest because a requested encroachment of 3.7 feet would not in any unduly and marked degree conflict with the ordinance, since the variance will not alter the essential character of the neighborhood, nor would the variance threaten public health, safety, or welfare. The small building encroachment once constructed, will have absolutely no impact on the surrounding area or any abutters.
Any questions or comments from the board? Okay, proceed.
Number 2, the spirit of the ordinance is observed because similar to criteria that the variance would not be contrary to the public interest, the spirit of the ordinance is observed because the whole purpose of the 40-foot setback is to prevent any impacts to nearby wetlands. In this instance, due to the nature of the wetlands and the fact that the encroachment is small, the wetland scientist for the applicant had clearly stated that there will be no impact to the wetland area associated with the requested setback. And in my request, I wrote engineer, but that should have said wetland scientist.
Okay.
And I have a letter here from Sanford Surveying and Engineering, Earl Sanford is also a wetland scientist. That was in your, yep. So I don't know if I need to read that, but just mention
no.
that for the record.
We have that for the record. Any questions, concerns, thought on number 2? All right, if you please, number 3.
Number 3, granting the variance will do substantial justice because this lot has been a lot of records since 1978. At the time the lot was subdivided, there were no wetland setbacks, and the only prohibition was building within the wetlands. As a result, this has been a residential lot of record for over 30 years, and the town has recognized it as a legitimate building lot. Recent assessments on the lot have varied from $170,000 to a present $147,000 value. Clearly, fairness dictates that the lot be approved for a single-family residential dwelling.
Questions, concerns, thoughts?
Nope.
Number 4.
Number 4, for the following reasons, the values of the surrounding properties will not be diminished. The proposed use is consistent with zoning in this area, specifically single-family residential. In addition, the lot is over 4 acres in size and can readily support the proposed use. There will be no diminution of surrounding property values.
Questions? Number 5.
Unnecessary hardship. Owing to the special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, 1, no fair substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property because, again, the purpose of the ordinance is to prevent wetland encroachments which could impact the wetland areas. In this instance, there will be absolutely no impact since the encroachment is not a request to build within the wetlands, but merely within the 40-foot setback associated therewith. Since there will be no adverse impact to the wetlands, there is no substantial relationship between the general public policy of the ordinance and the request being made. And 2, the proposed use is a reasonable one because it is reasonable based upon the current assessment of the parcel and the fact that the proposed use is permitted. Every effort has been made to create a design which minimizes any wetland encroachments.
Any questions? Actually, so overall, this was approved in, you said 2000, I think I remember actually sitting on this, but in 2013. So I'm looking at the house design. Is that the same exact one that was pitched back in 2000? I mean, is there any real changes on the housing design? I mean, I know the variance is there, but I mean, same type of house, same.
Yep. We didn't want to change that building envelope, but my client is actually proposing a smaller house that'll fit within that envelope that's shown on the plan.
All right. Lenny?
No problems with it.
Questions? Concerns? All right. Is there anybody, all right, so we'll close that discussion. Is there anybody in the audience that'd like to speak in favor of this? Is there anybody that would like to speak against this? Okay, we'll close the public hearing. In the board, discussions, questions, anything anybody wants to add, point out?
I think I think it meets the criteria of hardship, because it's been in existence for so long, because it was granted at one point. I think not granting this would create a significant hardship for the petitioner.
It sounds like it's only a matter of a month in between
Right.
the dates. I mean, I don't see a problem with it at all.
Tony?
I agree.
Okay.
I mean, since it's already been granted once, I don't see how we can say no.
That's not one of us probably heard it anyway, so,
Right,
Yeah.
so,
all right.
I agree.
Can I get a motion?
Mr. Chairman, I make a motion that we grant the variance under section 2.02A6 of the zoning ordinance to permit a residential dwelling to be constructed 36.3 feet from the wetland area, whereas 40 feet is required. The parcel is located at 53 Pearson Road in the R Residential District. Tax map 7D, lot 011-01, case 2015-41.
Second.
All in favor, say aye.
Aye.
All opposed? Abstaining, so 5-0. Congratulations. Thank you. Next one, and this is the one that's the big one. 'Cause it's been in the newspapers. The Monahan Companies, petitioner and Merrimack Premium Outlets LLC, variance under section 2.024.4D of the zoning ordinance to permit a mixed-use development conditional use permit to be sought from the planning board on a lot in the I-2 district, section 2.02.4D1A, to permit a mixed-use conditional use permit to be sought from the planning board on a lot with less than 50 acres, and section 2.024D1D to permit,
Whoa.
Hold on.
what's going on? Oh, okay. Didn't know the lights were going on. Okay. Sorry about that.
I know
folks.
it, I know I didn't drink that much.
To permit a mixed-use CUP to be sought from the planning board on a lot without 500 feet of continuous frontage on the state-maintained portions of Daniel Webster Highway. The parcel is located at 10 Premium Outlets Boulevard in the I-2 Industrial and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 3C, lot 191.02, case number 2015-42. Before we start our show, it says planning board in there. Should that be zoning board? It says planning board in that.
In the interim?
Yeah.
No, that's correct.
That is correct.
It should be sought from the planning board.
Planning board.
Yeah.
Okay. I'd ask if you could give us about a 5-minute presentation, but it sounds like it looks like it might be a little more in depth. So
We'll try to keep it brief.
that would be great. That would be great. And obviously, there's the 5 points I believe as well that'll need to be read in. So just make sure you sign in. Your mics are on, and gentlemen, it's at your leisure.
I think we've got it. Okay. Thank you very much, Mr. Chairman, members of the board. While my computer is booting up, we have kind of dueling presentation techniques only because I'd like the viewers at home to be able to see what we're presenting,
Sure.
as well as duplication prevents mishap. So, my name is Gordon Leedy. I am a landscape architect and planner with VHB in Bedford for the applicant, the Monahan Companies, and the owner, Simon Properties. This parcel, let me get... I'm sorry.
But I don't mean to cut you off real quick.
Yep.
Just so the board knows, there's a couple of variances here that we're looking at. My suggestion is we look at it as a whole as opposed to just
Yep.
each individual variance. Is that agreed?
Agreed.
Okay, thank you. Sorry, sir.
No problem. Let me find my, here it is. So just to give you an overview, maybe this will, there we go. Just to give you an overview, of the property. This is the site, or it's a part of what was the site for the Merrimack Premium Outlets. That was a 175-acre site that was approved in 2008 under the conditional use permit provisions for outlet village shops. The property that we are considering this evening is map 3C lot 191-2, which is approximately 20 acres of that original parcel that was subdivided as a part of the original approval. The property is an out parcel created during the development of the outlets project, located entirely within the I-2 district, and was previously conceptually presented as the site of a 200-room hotel and several standalone restaurants. Those uses are all allowed as of right in the I-2 district, as are a number of other uses such as banks, office buildings, industrial manufacturing, and what's termed supporting uses to the industrial district. So, as I said, we went through a conditional use permit process for the outlet village shops, similar to the conditional use permit process that allows mixed use projects in the I-1 district. So this neighborhood is surrounded on three sides by other industrial uses, some of which are in the I-2 district, some of which are in the I-1 district, some of which are in the I-3 district. But there are approximately 8,000 people who work on properties within a quarter mile of this site. So it's kind of the nexus of that industrial interchange area, which I think was the hope and desire of the town when they created this zoning scheme. Since the zoning allowing mixed-use projects was adopted by the town in 2006, the 2013 master plan called for expansion of that kind of development to other portions of town other than the I-1 district. Currently, mixed-use projects under a conditional use permit process are only allowed on DW Highway with 500 feet of frontage on DW Highway in the I-1 district on sites that are greater than 50 acres in size. So with the exception of the location on DW Highway, I would say that all of the other criteria for the purpose and intent of creating that zoning scheme are met by this site. It's the center of a significant commercial hub in the community, and it's part of a larger piece of land. So the master plan did say that for the purposes of expanding the tax base as well as creating diversity in town, that mixed-use projects should be allowed in other appropriate areas of town on smaller lots than are currently allowed in the I-1 zoning. But a zoning amendment to enact that policy decision has yet to be developed or approved. So I think it's important to recognize that this form of development that we're proposing, and I will go to the conceptual plan that we've prepared. This form of development is allowed as of right in the I-2 district, but for the residential component. So we're not proposing to vary the requirements of buffers from the adjacent residential neighborhood. We're not proposing to vary the requirements for building height or allowable density. We are saying that the market would like to see this kind of development, and in fact, it's the highest value development from a tax-based standpoint that could be developed on this piece of property. And under the conditional use permit provisions, there's an additional layer of protection for the town. So we're not asking this board to approve our ability to build this project. What we're asking is for the ability to engage in a dialogue with the planning board that has approval authority to vet the 10 criteria that are in the ordinance that must be met prior to approval of such a project.
You just said something that was kind of interesting. You said something about not necessarily this plan is what's going before the planning board?
Something very close to this plan is our intent. But I mean, we're still at a conceptual stage. We have to do design and so forth.
Realize that, and that's why, I mean, and I guess from the zoning board standpoint, if we're going to look and consider potentially breaking a variance, we're gonna, I think a lot of people on the board might be a little uncomfortable to grant a variance, potentially grant a variance, and then have something totally else put up there that wasn't necessary. Do you understand what I'm saying? It's like,
I do
this is what
understand
we're
what you're
doing,
saying.
and
This
something else
this
comes
is
up.
our intent, and through the process of the conditional use permit application, there may very well be modifications to this plan that are requested by the planning board, and to that extent, you know, we obviously would do everything we can to meet their requirements to gain a project that is acceptable to all parties. So, but you know, this is our story, and we're sticking to it, Mr. Chairman.
I appreciate the clarification, but you understand what you understand.
Yeah,
what was asking,
I certainly do.
something like that. Okay.
The criteria are actually quite extensive, and I can go through them.
We actually do need to have them read into record, and we will be stopping after each one if there's any questions
Well, this
regarding that.
is not the points of law. This is the criteria for the
Oh, I'm sorry.
conditional use permit.
Okay. If you want to go on to the points of law, we can do that. The criteria we have, I think we've seen.
Well, let me just go through the details of this plan, and then we'll turn it over to Attorney Leonard to review the points of law.
Sorry.
The applicant.
I'm sorry.
Excuse me, sir, can
Yes.
I ask one question?
Yes.
After I turn my mic on? Did you say that this is the plan that you're going to present to the planning board? There'll be no changes
Conceptually.
and
Well,
conceptual?
conceptually, yeah. It's a two-pronged process. There's a conditional use permit, which needs to be vetted. As I said, there are 10 criteria for acceptance. If we don't meet those criteria, then the board has every right to deny the conditional use permit. Once the conditional use permit is approved, there's a site plan process. So the site plan process is where, you know, the nitty-gritty details of the engineering and so forth are developed. So until we get through the conditional use permit process, the plans are, by their very nature, relatively conceptual in nature.
May I contribute to that answer? My name is Thomas Leonard, and I'm here on behalf of Mr. Monahan and the Monahan Companies as well. I'm a lawyer in Nashua with Welch, White & Fontaine, 29 Factory Street. And I understand your concern, and I think it probably is worth explaining a little further exactly what it is we need to do today. So what we are really doing is we are in a zone that right now does not allow for a mixed-use development. The sister zone, I-1, does allow for it. So we are simply asking that you authorize us to proceed with a mixed-use development in the same way if it were zoned I-1. And what that really means is that we would then take this variance and go to the planning board through this whole conditional use process. Assuming we got that, we would then take the plan through the site plan and subdivision if necessary. So the intention is to present a concept with specific design along these lines, but because we are so far in advance of an actual engineered and designed plan, we have to be careful what we say in the sense that we don't know what the planning board will be willing to consider. But I think it's important to understand that this board, all we're really asking for is that this board allow us to proceed the way the town has required mixed-use developments to proceed. It's really just that very early step. We are in an I-2 zone, which does not allow mixed use at this point in time. We need your okay for that, and it's the very first step that we need to make.
So just to clarify, to make sure that I understand, and that so that we're also on the same page, it sounds to me like because this is a conditional use permit, as opposed to a single building or a house or some of the other types of variances that we typically see, what we're looking at tonight, the conditional use permit, is something that we won't be looking at. That's something that's the focus of the planning board.
That's exactly right.
So for us, the request is, will we grant you the ability to treat it as an I-1 industrial zone?
Yes, and you can expect that we need to meet all of the criteria and the review that the planning board would call for at the conditional use permitting stage and at the site plan and subdivision stage. So there's
and that would be a more extensive process.
Way more extensive with all kind. They get to ask us for any information they want.
Okay, that's what I thought. I just want to make sure.
No. I just have a question of Jillian. If we approve this to the planning board tonight, once they go through the planning board and they're approved, do they have to come back to us for the final items on there if there are specific changes that are going to affect the zoning board, because they say this is just conceptual?
If the variances are granted tonight, they can then proceed to the planning board to seek a mixed-use conditional use permit. If anything came up in that process that required zoning relief, then they would have to come back to the board. But if it didn't, then they wouldn't have to.
I mean, I don't want to belabor the point here. I'm just looking to approve a concept that could potentially change. I'm just curious as to why, because and here's my thought process: why you wouldn't have gone to the planning board first and got the concept and the idea, and then had kind of the planning board's a little bit of the backing. And I say that from the sense that, let me finish. The zoning board, we have more of a judicial authority than the planning board does. In granting a variance, we're kind of giving the planning board, almost our thumbs up on it. But the planning board is obviously got to look at the conditional use. They got to look at how you're going to use it. The other aspect of it is, if for some reason the variance doesn't pass tonight, this is you guys. So without having gone to the planning board and put together a firm idea of what you're looking for, if for some reason, whether it passes, if you end up losing, then you'll end up you're going to have a very hard road to appeal. So I'm just kind of curious as to why you wouldn't have gone to the planning board first to get specifically, this is what we're looking for, get their backing, and then come to the zoning board, because if it goes the other way, it's going to be very,
Well, this is all about getting approval to present a mixed-use program, complex. We are not, right now the planning board would not have authority to review this plan because in our zone, they don't have authority to review a mixed-use complex.
Even though even though Merrimack is the 10-year whatever the long-term plan wants to mixed use. I mean, why don't you get your insight on this?
There's two things involved here. First of all, this property could be developed just the way they want to do it if they did not have the residential component to it. If they made those apartments offices, they wouldn't even be here. That's the only reason that they're here. And they want to do this. So they want to go to the planning board and say, rather than just doing pure office space or pure commercial space, we want to include a residential component in this development. And that's what makes it conditional use.
Okay.
Okay.
That's also what makes it mixed use.
I'm sorry, mixed
Yes.
use, yes.
Yes.
They can't go to the planning board because the planning board has no authority to grant any kind of permission for there until we say, yes, we will give you a variance, essentially to include the residential piece in what we want to do in the I-2. Now, if they were in I-1, they wouldn't be here either. And some of the criteria, I think, that makes it reasonable is the fact that our master plan that we just went through and approved has said, we haven't acted on it yet, but has said we really should be expanding this into other areas instead of just including it. Right now, we can only do it along DW Highway.
No, and so the municipal.
And so there, if the zoning presented ordinances to make this change, then they wouldn't be here either.
Okay.
But this is what, so they can't do anything until we say, yes, we'll give you a variance so that you can do that.
Okay. All right. Do you want to do
Yeah, I just wanted to say, I understand what Lynn is saying completely. But the problem I have is sort of granting carte blanche to them.
All right. Well, let's hold that discussion until we actually hear the rest of this. Can we get into the 5 points of law, please? I mean, as far as the overview, I think we all have a pretty good idea of what we're looking to
Okay,
put in there as
fair
far as
enough.
mixed use. Very good diagrams, very good conceptual drawings. If we could get into the 5 laws, that would be great.
Okay, again, my name is Thomas J. Leonard, and I'm going to present this part of the application. You have the application before you. I think there are some important things to discuss kind of in the conceptually here, and that is, of course, a variance depends an awful lot on understanding the purposes of the zoning ordinance and the purposes of the particular regulations. And again, to be very specific, and I think this is important, we are asking for a variance from section 2.02.4D.
We
Well, it allows mixed use in a I-1 zone, but does not allow a mixed use in an I-2 zone. All we're asking for is permission on that mixed use. The next 2 variances that we request is permission to put the mixed-use development on a lot less than 50 acres. That's a requirement if you were to proceed with a mixed use in I-1. So we are taking those same 7 pages of regulations that apply to mixed use, and we are saying to the planning board and to you, we know we're subject to those rules. I think there are 6 full pages of regulations that just apply to mixed-use developments. We know we're subject to that. The last 2 variances really relate to just 2 of those items on the 5 or 6 pages. One is the 50 acres, and one is the 500 feet of frontage on DW Highway. The 50 acres I will address in a moment. The 500 feet on DW Highway, of course, I-1 is along DW Highway. That's the reason for requesting that variance. We are not on DW Highway. We do have more than 500 feet of frontage.
I understand what you're saying. I understand you're getting a point across.
Well,
I understand. We know where it's located. We're aware of the square footage. We're aware of the frontage. We're aware of the variances.
so the purposes of these ordinances,
Yes.
the master plan is very clear on what its goals are and what the goals of the zoning scheme are. And the master plan has identified a number of things that are going on. They have been going on, and they are going on now. They've identified a change in demographics. And specifically, some people are getting older. We are trying to bring in younger people. The master plan specifically talks about boomers and Generation X, Generation Y. And the reason that's important is that the whole mixed-use scheme is specifically intended to bring what is referred to as live, work, and play synergy. That's the purpose of these ordinances. The reason I have to talk about the purposes is this whole variance is based on, we meet all the purposes of zoning. We are, what you see before you is an integrated mixed-use program that specifically meets the goals of the master plan. It brings diverse housing. It's a kind of housing that is not otherwise here. And the master plan has specifically asked for diverse housing. It may be for boomers, it may be for young Generation X and Y folks, but the idea is this is a housing that is not otherwise available in town. And it's integrated into a complex that is identified for areas in town that have excellent infrastructure, specifically highways, sewer, water. We have all those things. In the master plan, it specifically says that the purpose of the zoning is to cause these kinds of development to infill in smaller tracts and support surrounding uses. So we have surrounding uses that are actually calling for this kind of project. There are employers out there, obviously 8,000 people employed within a quarter mile. This is the kind of project that they want to support those existing employers and the existing uses surrounding. The master plan specifically says that that's why you want to have mixed-use complexes. The other thing that I think is important to point out is that aside from the housing and aside from the live-work-play synergy that is obvious from this kind of program, is that it affords the town an opportunity to continue the rural program that it wants outside of these core central areas served by the infrastructure. And that is also stated in the zoning ordinance, and it's stated in the master plan. So this general purpose that we're talking about is important. The purpose is restated in the ordinance itself, and I think it's worth reading in the ordinance. It flat out says that mixed uses allow for creative integration of industrial, commercial, and residential housing developments based on master site development. And they do this in areas that are where it's an appropriate use of land, where it's fiscally beneficial, where it's efficient use of public services, and where there are expanded opportunities for diverse residential development. That's exactly what we have here. We have a situation that has all of the needs for this kind of project, and it supports the surrounding uses. So with those uses in mind, going to the criteria, granting a variance will not be contrary to the public interest. And I heard earlier discussion about the Chester Rod and Gun Club case. That case is not about a gun club. It's about the principles that the Supreme Court for New Hampshire used and explained in understanding this requirement of not contrary to the public interest. And what the court said in that case is, when zoning boards look at what is in the public interest, they also are considering what is in the next number 2, proposed use will observe the spirit of the ordinance. Those two requirements are very similar. And the idea is that, does the variance and the proposal meet the goals of the zoning scheme in the town? Can it be accomplished without specific concerns to public interests? Basically, what the Supreme Court said is, so long as this proposal does not alter the essential character of the locality and does not threaten health, safety, and welfare, then it can be said to be consistent with the public interest and consistent with the spirit of the ordinance. So that's the importance of that case, not about a gun club. Here we have a situation where the proposal meets all the goals of the zoning ordinance. It happens to be off of Daniel Webster Highway, but the use is very appropriate given the infrastructure and given what both the zoning ordinance and the master plan have identified as important criteria for this use. The 50-acre requirement is not necessary in this particular circumstance. Here we have a 20-acre area that needs to be infilled. You want a dense project, on this site because it's good for the town, and it allows a new kind of housing, and it supports the existing uses, the employers. The hotel supports the outlet. So this all works together, and it's right on the main highway, which of course is part of the intention here. And similarly, the 500 feet, as it relates to public interest and spirit of the ordinance, that 500 feet is met. The purpose of having a 500-foot requirement is just to make sure that you have some flexibility in design, you have a relatively large site, and you can have a project such as this integrated by a master plan. That's the purpose of that ordinance. Yes.
We understand, you don't have to explain to me what the ordinance is. Okay, let me finish.
Yep.
I understand what the ordinance is. And you're explaining this whole thing to us like we don't know what the ordinance is. But we do know what the ordinance is. So I would appreciate it, as one member, to go with the criteria and start doing the points of law so you explain to me what I already know.
I apologize if I'm offending you, sir. I understand.
You are.
Okay. I understood that the points required a discussion of the purpose of the ordinance. So,
Pat?
No, the points are only reading, and then you stop after everyone, and we discuss it or ask questions.
All right.
Okay.
Hold on, one more, please.
Yeah.
I think I disagree with Tony a little bit. I think,
Well, can we leave that for discussion? I really like to get the points right off.
well, that's my point.
Okay.
I think he is addressing the points of law. He's doing it in a dialogue rather than one at a time. And I think if you can break it down, the dialogue down into just the individual points rather than blending them all together, that would help.
Okay, so would you like me to read number one in?
Verbatim.
Yes,
Okay.
it would be helpful, please, thank you.
The proposed mixed-use development is on a lot that is zoned for commercial and industrial use and is a site appropriate for infill development. The transportation and utility infrastructure available to the site supports the proposed use. The proposed uses are permitted uses except for the residential component. The zone permits hotel uses and perhaps long-stay hotel uses, but does not allow for the more typical residential uses. The proposed residential component is in a mixed-use building where the residences are on the upper floors. It is a use that is a new use to the town of Merrimack, but in demand. The 2013 Merrimack Master Plan supports the idea of diverse housing, and the 2013 Merrimack Master Plan also supports the notion of increasing both tax base and diversity of use through the development of additional mixed-use projects in the town. Granting a variance for a reduced lot size and frontage is required by the ordinance, is not contrary to the public interest because the parcel is actually an out parcel of a larger project. The larger project had ample frontage and ample size to accomplish the purposes of the ordinance. The proposed project is not contrary to the public interest because it will provide enhanced tax revenue to the town. It provides a variety of residential units not currently provided in the town, and it provides a substantial amenity to more than 8,000 employees working in the immediate vicinity of the property. To be contrary to the public interest, the variance must unduly and in a marked degree conflict with the ordinance such that it violates the ordinance's basic zoning objectives. And it cites that case. This proposal will not alter the essential character of the locality because all the uses are permitted except apartments. The proposal will not threaten public health, safety, or welfare because of the sufficient and appropriate supporting infrastructure.
Any questions or concerns?
I just have one question here.
Please.
States it provides a variety of residential units not currently provided in this town. What do you mean by that?
Well, this is more, and I think it was referred to in the staff's review of the project. It's a residential program where the first floor is retail, and the upper floors are office and or residential, so that these are apartments over a different use, and that's a different kind of proposal.
Because I was going to say, we've got apartments, we've got condos, we've got private homes, we've got duplexes. We have all of it here.
Not over
The
Apartment is an apartment.
The other piece of this, though, is that as a part of a mixed-use development, this is a more modern approach to that than segregating the uses. And it is a place where there will be a walkable environment within the project, so that if young people, for example, want to are working at Fidelity or at Atrium or whatever it's called now, and they don't want to have a car, for example, and they want to live near where they are, and they want to be able to go to a restaurant or a pub or something for entertainment purposes, or they want to pick up sundry items and so forth. This is an environment that allows that to occur, and I would submit to you that doesn't really exist elsewhere in Merrimack. It may not be your or my cup of tea, but it is actually demonstrated to be pretty much the hottest piece of the real estate market right now.
I just can't picture anybody who lives in this town that doesn't have a vehicle. You need a vehicle to get around the town, but that's me. Okay,
Number
Tony,
two.
did you have something?
Yeah, I did.
Oh, sorry, hold on.
This is a similar situation. It's a similar operation in Guilford. There is a similar plan, or it's already there.
In Guilford?
I think it's Guilford. It's outside of the Weirs.
Oh, yeah, could be.
Okay.
Yep.
They have the buildings, the retail buildings on the bottom, and you have the apartments on the top.
And actually, there's
Is that a
another.
similar
Yeah,
situation, you feel?
there's another model that I would point to, Mr. Pellegrino, which is Port Walk in Portsmouth,
Yep.
which
Yep.
that's very similar to the kind of atmosphere that we're trying to create here.
So you want to bring that type of atmosphere or that type of project into Merrimack?
Correct.
Okay. Thank you.
Number two.
The spirit of the ordinance is observed because the requirements that a variance be consistent with the spirit of the ordinance coexists and is related to the requirement that granting a variance will not be contrary to the public interests. But for the residential component, other uses on the property would be allowed in the I-2 district. The siting of significant development in areas of the town that are supported by transportation and utility infrastructure is a principal tenet underlying the zoning ordinance. Tenet is misspelled. The proposal is a modern mixed-use concept that is particularly complementary and appropriate to the area.
Any questions? Number three.
Granting the variances would do substantial justice. The substantial justice inquiry requires the ZBA to examine whether any loss to the individual by strictly enforcing the ordinance is outweighed by a gain to the public, to the general public. Here, the uses are consistent with the present neighborhood and consistent with the surrounding infrastructure. The mixed-use project is the highest and best use of the property. Present regulations for the conditional use in District I-1 establish criteria and guidelines which enable the town to properly review and approve a mixed-use project. With regard to a mixed-use project in this particular area of town, there is no reason to strictly enforce the ordinance. The loss to the property and the property owners would be outweighed by any gain to the general public. There is no gain to the general public. The property is a portion of the original development of Merrimack Premium Outlets. There is no reason to strictly apply and enforce the frontage and lot size requirements in this context.
Any questions? Number four.
Number four, the values of the surrounding property will not be diminished. The setbacks and other zoning provisions which, with respect to adjacent residential properties, are proposed to be followed in this in this development. The setbacks and buffers of residential properties will protect the existing residential properties from any adverse impacts. The value of adjacent residential properties will not decrease. The value of adjacent commercial and industrial properties will likely be increased somewhat by providing amenities available to the employees of those facilities.
Questions? Number 5.
Owing to special conditions of the property that distinguish it from other properties in the area, a denial of the variance would result in unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of the provision to the property. The general public purpose of the mixed-use provision is to allow mixed-use development on an undeveloped parcel where adequate transportation and utility infrastructure exists to serve them, creating diversity of both commercial and residential development in the town. This property meets those criteria as well, and although not located on Daniel Webster Highway, it is at the center of significant employment and commercial activity in the town and is accessed directly from a state roadway. No fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific ordinance provision because the 2013 Merrimack Master Plan supports the notion of increasing both tax base and diversity of use through the development of additional mixed-use projects in all commercial and industrial portions of town. And the proposed use is a reasonable one because mixed-use development is permitted by conditional use permit in other industrial districts with similar characteristics as this property. Other dimensional and density provisions of the district are proposed to be met, and the development will be similar in appearance to others allowed to other uses in the district.
Thank you.
So I apologize for,
No.
I didn't understand what you wanted, and I apologize for that, but certainly can try to answer questions.
No problems. Are there any questions before I open this to the public?
I just want to say I was excited on this situation. I got a short fuse.
No. I
So-
appreciate the discussion, to be honest with you, because it's a
He's
very exciting
He's
project.
Italian.
It's a very exciting
I
project.
just did not see where you were going with this, that's why. And you explained this whole thing that I already, I don't know it as good as you do. Of course, I don't get as much money as you do. But anyways, I'm just saying that, I just didn't see where you were going with this.
Well, I appreciate you directing me.
So let me open this up to the public. Is there anybody out there that would like to come forward and speak in
Oh, I
favor?
still have the question. I'm sorry.
Right back to that.
Okay.
Anybody to speak in favor? You'd like to speak in favor? Yeah. All right, please come forward. Can you raise your right hand, swear to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
Can you please sign in and state your name, please?
Yeah. Chris Ross, 401 and 403 GW Highway in Merrimack. I've been watching this development for a while, and I have to, come here. I really want to go home. I'm exhausted, but
I understand.
these guys have done a great job taking that piece of land and developing what they developed. I think a lot of people would agree that Merrimack has always had a lot of properties that needed attention, and these guys came here and developed a beautiful site. I think they pay attention to detail, and I think that the planning board and Tim and his staff will do a great job directing them as to how to lay this thing out to make it look better than what it does right now.
Right.
But I have seen the examples of what they're trying to do. He is correct in saying that, it is the kind of the latest and the greatest. You're building a community. You have that daytime activity going on, and then at night when it closes down, it's not desolate and open for whatever to happen. You've got some residential people there that are kind of keeping an eye on things, so that is a good that is a plus. And like I said, I think that I support it. We don't have, to answer Fran's, statement, we don't have anything like this in town. We have, rundown condo facilities. We have a couple of new apartment buildings. We have Society Hill that's holding on, but a lot of stuff is kind of run down. I mean, they're bringing something that's kind of new and upcoming to Merrimack, and I think it'll do very well. And on the tax base, he's right. I mean, if you've got a bunch of retail space versus the retail and the residential, you are increasing that tax base, and I think that the police department, the fire department, and the schools would like to see that. So there's really, no reason why they shouldn't get just what's called the green light to go to the planning board and discuss this further, and I hope you guys take this into consideration.
Thank you very much.
Yeah, thank you.
Thank you. Is there anybody else that'd like to speak in favor of this variances? Anybody that would like to speak against these variances? Please come down, sign in, please, and then state your name.
Yeah, I'm Nancy Harris. Actually, I'm sort of between. That's why I'm really here first against it, because I'm not really totally against it.
Okay.
The reality is, it is approved for what it's approved for already without coming here. The difference is the residential. But I did want to point out one issue that has to be consideration regardless of what it is. But since it's part of the 5 points of law for the zoning, I wanted to bring it up for discussion. I am an abutter to this property, so I know what's allowed and what's not allowed. Conceptually, it's not a bad deal. To be honest with you, I think it's a really upscale, high-class thing. But the reality is, as it's presented, it does affect the value of the properties in the following way. If you look at the entrance, and there's the roundabout, and then you come in, you have this wonderful display of green trees. Well, if you were in our houses right now, there's no green left because it's all leaf-losing trees. And there's a 100-foot buffer. That's understood. That would stay the same. But if you come out, all those headlights are going right into people's houses. That buffer does not provide any protection at all. So in that respect, I would debate that it's not going to affect the value of those, I think it's 7 houses. Now, I'm not sure, and you may not have this information yet, but the kind of traffic that you're projecting?
Actually, you got to, Nancy's got to
sorry.
come this way. Sorry.
Let's say it's 800 cars a day.
Yeah.
Which is probably a reasonable thing. You're talking about 800 cars, never mind the trucks, never mind the service vehicles, never mind the garbage trucks, all those things. And depending upon, and I know some of this has to do with the planning board issues, so I understand that. But I think it should be addressed in terms of the points of law. And I could probably get 2 people in here saying it will diminish it. And they can get 2 people say it won't be diminished. But the reality is that it is going to impact because of the circumstances. Now, my only thing, and I will bring it up when we're talking about the planning board if it goes that far, there has to be some sort of, I'm not sure, the term's not mitigation, but there has to be some sort of method by which those houses are protected from the noise, from the sound, the visual, all the headlights and the lighting. It is going to impact. So I'm not sure if there's anything the zoning board, if they choose to, no. Well, but at least I'm making it public.
No, it's a valid point, and I think that obviously this is if approved, the next step would be to go to planning, and the next step would be and obviously they're going to meet, they're going to speak to planning, and planning is going to put requirements in place. One of those requirements in place could be either a wall or a berm or something that would cut that noise and cut the lights out, and that's a very valid point. And so. But that is really going to be a little bit more of a
planning board issue.
And a planning discussion. I think Lynn might be able to
It's
talk a little bit about
That's strictly a planning board issue.
Right.
But the other point I'd like to make is this picture that's on the screen
Right.
is not what is
Understood.
being proposed.
Understood.
It's just an idea.
But you're
And when
making
they
a
actually-
decision
but-
on the idea,
But
in a way.
we're not making a decision on that picture.
Okay. Just
We're
the
making a
concept.
decision on whether to allow these residential units
Right.
in this property. Now, when they go to the planning board, they may have a totally different picture, maybe because they listened to what you had to say tonight. But,
It's also a little too dense, but we'll get into that later.
well, and again, that's a planning board issue. All we're trying
And
to
that's why I didn't
determine
bring it up.
tonight is whether having these residential apartments on this site makes sense and is beneficial.
And that's why I'm not for or against
Yeah.
it. Because personally, I don't think the residences are going to make a difference. Personally.
Understandable, yeah, no.
But I also wanted to at least address one of the points of law that,
Yep.
if they're listening, might be able to be addressed even before it reaches the planning
Yep.
board.
No, thank you very much.
Okay, thank you.
Thank you. Is there anybody else that would like to speak against this variance? Please come on down. Feel free to sign in and state your name.
Hi, I'm Barb Amaral, and
Sign in.
yeah,
Sorry. Hi, Barb.
hi. I'm also a butter. I'm at 1 Spruce Street, and one of my big concerns is the access road that comes out onto Camp Sargent, and as to whether that will remain an access road only, or whether there will be an entrance opening to Camp Sargent. If that's the case,
Planning board.
traffic is going to be a disaster on Camp Sargent. There's already issues on Camp Sargent with people speeding right past my road. There's kids.
That would be, so to answer your question, or to try to give you an answer to the question, is unfortunately the final site, like if there is going to be, is going to be planning board, not zoning. Understand the concerns. That would definitely be something that you'd want to make sure that the planning board is taken into consideration. And obviously getting it into the record now is something that, when they go to do the final plan, that would be something you definitely would want to have there. As far as, again, as a conceptual drawing, I don't know if that road is going to be there or not, or if it's going to go out onto Camp Sargent, or if it's going to go out onto Continental. I'd imagine they have to have another entrance out. I don't know if it necessarily has to go on to Camp Sargent. It could potentially go on to one of the other, it could potentially go on to, Continental. But that would be something for the final plan that they would be able to do. But no, I understand what you're saying.
Yeah,
about
I
that.
mean, I understand that's a planning board issue, but I think it has to also be taken into consideration if you're considering changing it to residential.
Yes.
Another concern is, can Thornton Ferry School handle additional children that might become residents in this apartment, in these apartments?
Again, that would be that's planning. I'm just, there's only, so when someone like comes forward, when someone comes to the zoning board, they're looking at getting the approval to be able to talk to the planning board about putting this in place. The finals, as far as whether lights on homes, exit roads, number of apartments, number of stores, square footage, all of that is legitimately through the planning board. And the planning board isn't necessarily going to give somebody carte blanche. They're going to have discussions, and more than likely multiple discussions regarding the design, the layout, and how it will affect or won't affect the residents locally. We're just here to say or not to say, yes, you can go forward and talk to the planning board. So can't really, I understand. I can't say about the schools. That would be more of a planning.
Well, I understand, but I guess it's just, if there's not going to be a residential area there, then that issue wouldn't exist to begin with.
Well,
So-
and to Lynn's point, who's on the planning board, if they weren't going to do residential, they could put that in right now, and they could put an access road there, and they wouldn't need to get any zoning variances, and they wouldn't be here at all right now.
I thought it was not zoned for residential.
If they weren't doing the residences, if they
Oh,
weren't doing the
correct.
apartments, they could put something in there right now.
Right,
without
yeah,
coming to the zoning
I'm
board.
talking about the residential
That's
addition
and again,
to
that's
it.
the only reason that we're here having this
Right.
conversation tonight. So.
So I guess I was just trying to make points that
Yep.
might come into play if the residential aspect is added.
And those are good points, and it's something that we do look at when we look at, the planning board looks at it more than we do, but yes, no, I understand what you're saying.
Okay,
Anything else?
I think that's it.
Okay.
Thank you.
Is there anybody else who'd like to speak against? Okay.
My name's Charles Brano. I live at 3 Spruce. Zoning this residential. I have a concern about this. You brought up a good point, and I thought about it while it was going on. What kind of cost-effective housing are we talking about here? Are we talking low income? We're doing it above residential space. When I hear this, I think Nashua, downtown Nashua. Nothing wrong with that.
Mm-hmm.
I'm thinking South Nashua. I'm thinking these places where this is an afterthought. We can make more money or keep this place alive later in the evening by throwing residential on top of this stuff. I don't know if I see a benefit to that as an abutter to my home value. I'm not sure I see how this is going to increase my home value. I'm sorry, I don't agree with that. I don't see how that could happen with this kind of residential here. It was not discussed what kind of residential, what kind of costs we're talking about for these. I'm assuming, and I have to go with this thought, it's low income. I have to assume that, unless somebody can prove me otherwise. This diagram is really beautiful, and I understand it's just an illustration. I get that. What I don't get, though, is why we're going to put more housing in an area that doesn't really need it. I'm not sure. We have a lot of empty space here in Merrimack. Why are we going to build more and keep the empty spaces empty? I don't understand that logic. I probably won't understand it even when it's done. And when it is, I'm sure this is going to go through. Something will be built on that parcel, against my wishes. I'd like to keep it empty, but I can't do that. I do have a problem with residential there. I have a problem with the fact that once it goes past this board, the planning board, and it gets implemented, and all of a sudden I have to look at this stuff, and I have to look at what's going in and out of there, and I'm not saying it's going to be good or bad, but my gut tells me this is not going to be good for me. I get enough traffic on my road from the outlets. What makes me think I'm not going to get more traffic from other people, especially a retail area, a residential area, a hotel, when we have a vacant one in Merrimack? I'm not sure I understand how this is. I understand it's not what this board is for. But the residential part, I don't see how that's going to benefit the town of Merrimack. Are we talking more tax revenue? Barb brought a good point about the schools. How are we going to, the infrastructure, how good is the infrastructure here? And it's going to support that if there are more children. The 8,000 people that are employed within a quarter mile, how many of those work in the outlets? How many of those people are already employed? Will there be turnover? Yeah, there will be turnover. There'll be a lot of turnover over time. But are those people going to live in those residential areas? I doubt that. I highly doubt that. That's my concern.
Okay.
And that's all I have. Thank you.
Thank you. Is there anybody else who'd like to speak against this project? Okay. Close the public hearing. Does the board have any final questions for gentlemen?
Yes, I did, remember?
Oh, you do.
Go ahead.
Please.
Just a quick question. Your 500-foot frontage, now does that go right up to the roadway?
The requirement in the ordinance is that a mixed-use project have 500 feet of frontage on DW Highway. We obviously don't have that. We do have over 1,000 feet of frontage on Industrial Drive and over 1,000 feet of frontage, or about 1,000 feet of frontage on Continental Boulevard. The access to the property is pretty much dictated by both the zoning ordinance and by DOT as being where it exists today. So the access to the property is going to be at the signal at Premium Outlets Boulevard. There is no other access that's allowed under the provisions of the zoning ordinance.
Because I was going to say, the state owns part of that roadway, if I remember correctly.
They own both of those roadways. And in fact, the right-of-way along the Continental Boulevard and the Industrial Drive frontages is what they call controlled access right-of-way. So the access scheme was developed when they put the industrial interchange in, and they determined that it should be across from Spartan Way, and so that major intersection has been developed to handle the traffic from both the outlets and from this development program. Just for the board's information, we have done there was a certain amount of development, as I mentioned earlier, that was conceptually presented to the planning board during the outlets project, and also was incorporated into the driveway permit that was granted by DOT for this overall project. We've done an analysis, a preliminary analysis, and determined that based on this development program that you have in front of you, the additional traffic would not require any off-site improvements, and that there's sufficient capacity in the roadway to handle that. We will need to do some internal improvements like this roundabout that doesn't exist today, but the intersection on Industrial Drive, the operations on Industrial Drive, and on Continental Boulevard will not be negatively impacted by this development.
Any other questions? Lynn?
I just have a comment regarding the residential units and who is going to live in them. I've been on a number of commissions up at the state level talking about housing in the region, not just in New Hampshire, but in the region. And from all of those that study it, there is an indication that there's a need for young professional housing, and that the young professionals are, by and large, not buying. They are renting. And that there is a low number of children, that these are young professionals who are delaying families. And what they're finding is in these areas, and there's a number of them around the area. Tara Heights down in Nashua is a classic one. Those are very upscale apartments, high-end, and they're not occupied by retail clerks. They're occupied by young professionals that are working in the BAEs, in the Fidelities, in the Atriums, that want to live close by to where they're working. They want to walk to work. And that's not just in New Hampshire. Like I said, this is regionally what is being demanded by this age group. And I think that's the age group that we're targeting, that we don't have that type of housing in town to bring them in and keep them here. And I think those are the ones that we'd like to attract.
That's a very good point, and that's exactly what our thought process has been. Tom, these are for rent? Yeah, these are going to be for rental apartments. What we have in the plan so far is a mixture of 1- and 2-bedroom units. They're not going to be so-called family housing. My take on it is that the projected, once we do the analysis, the projected school children from this is going to be extremely low, and this is going to be market rate housing. It's not going to be affordable housing or low income housing or whatever. You're absolutely right. This is housing for that in discussions with employers in the community, there is a real need for this kind of environment to, as you say, attract and keep talented young professionals.
Tony?
Yes. Did you say there was a preliminary study on traffic on this project?
We did a sort of due diligence level.
What's a due diligence?
Due diligence level is basically a preliminary analysis to. We did some traffic counts to confirm the projections that we had made when we did the permitting for the outlet center. We incidentally found that our total prediction for the outlet center, based on actual counts taken, I believe in August, was off by I think 25 trips. So we were pretty good at predicting what was going to be generated by the outlet center. We then applied the various other developments that are foreseen, and then put on top of the system a preliminary trip generation from this development. And I don't have the number precisely, but we did determine that there was adequate capacity in the adjacent roadway system to handle the traffic from the development.
Okay. Sorry, go ahead.
Did you estimate how many vehicles will be used in this project, going back and forth with the apartments and the retail
Yes.
and the hotel? How many cars are you talking about?
I don't, like I said, I don't have that number. It is, as I indicated earlier, there was after the approval of the outlet center, there was never zero traffic that was attributable to this site. So what we're looking at is an increase over what was previously permitted, and we will need to go through an additional DOT as well as town process to permit that additional traffic. And there will be detailed studies provided to the planning board, both as a part of the conditional use permit process and as a part of the site plan process.
So what you're saying to me is that you just used the previous traffic study from the outlet and just doubled it?
No, that's not what I said.
Oh, okay.
What we did was we took that as a basis. We confirmed the assumptions from that study by doing counts, actual counts of the roadway network, and then we did an analysis that added the additional traffic that is assumed from this development, and determined that there was adequate capacity in the roadway to handle that traffic.
Thank you.
One more from me.
Okay.
How long ago was this traffic study done?
It was August of this year.
This year?
Yeah.
And what days of the week?
We counted Saturday midday peak and I believe it was a Friday PM peak. So when you talk about traffic impacts, you don't talk about daily traffic, you talk about peak hour traffic.
I understand that. I understand that. That's why I wanted to know when it was taken and what days of the week it was
a Saturday
done.
midday and a weekday PM. It might have been Thursday, it might have been Friday, I'm not sure.
Okay, thank you.
Thank you. All right, so that, I'm going to close public discussion from the board.
You just close.
Okay, I'll just close it again. Can I have a motion from the board if there's no further questions?
I'll make the motion to grant Monahan Companies petitioner and Merrimack Premium Outlets LLC owner variances under 3.02.4D of the zoning ordinance to permit a mixed-use development conditional use permit to be sought from the planning board on a lot in the I-2 section 2.02.4 D1A to permit a mixed-use conditional use permit to be sought from the planning board on a lot with less than 50 acres, and section 2.02.4 D1D to permit mixed use conditional use permit to be sought from the planning board on a lot without 500 feet of contiguous frontage on the state maintained portion of Daniel Webster Highway. The parcel is located on 10 Premium Outlets Boulevard in the I-2 Industrial and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 3C, lot 191-02. Case number 2015-42. And I'm just taking a look at the staff recommendations. So as far as the standard review goes, it is the burden of the petitioner to demonstrate 5 requirements for granting the 3 variants have been met, which we've discussed. Staff also recommends the petitioner shall obtain approval for a conditional use permit from the planning board to allow the site to be developed in accordance with the mixed-use conditional use permit requirements of section 2.02.4D of the zoning ordinance, and that the petitioner shall obtain all necessary site plan and subdivision approvals from the planning board that are necessary following approval of the mixed-use conditional use permit.
Do I have a second? Second. All in favor, say aye.
Aye.
All opposed? 5-0. Gentlemen,
Thank you very much.
good luck with the planning board.
Thank you very much.
We're going to take I realize a lot of folks are here. We're going to take just a quick 5-minute recess. Everyone just stretch your legs, and we'll get right back to it. I apologize. Thank you. Lynn's not back yet. I'm going to get this going because I don't want to be here. All right, everybody ready? Thank you very much for the allowing the recess. It was a little bit of a longer presentation than expected, but nonetheless, we move on. So, next petitioner, Sean Farrell, petitioner, and Brett W. Vaughn, revocable trust, variance under section 3.02 of the zoning ordinance to permit a subdivision with a lot containing 209.90 feet of frontage, whereas 200 feet is required. The parcel is located on Wilson Hill Road in the R1 Residential and Aquifer Conservation Districts, tax map 4A, lot 004, case number 2015-43. How are you?
Very good, and yourself?
Not bad.
Thank you, Mr. Chairman, members of the board. For the record, my name is Chad Brannon. I'm a civil engineer with Fieldstone Land Consultants. With me tonight is Sean Farrell, who's the applicant, and we are before you seeking a variance under Section 3.02 of the zoning ordinance to permit a 3-lot subdivision of tax map parcel 4A-4.
So, just real quick, not as long as the last one. Can you just give me a 5-minute, not even 5 minute, less than 5-minute overview? Why are we here? What are we doing?
Sure.
And then we'll get into the points of law.
That sounds perfect. The subject property consists of approximately 28.03 acres of land with 709.9 feet of frontage along Wilson Hill Road. Section 3.02 of the zoning ordinance deals with lot sizes and frontage in the R1 district. More specifically, 3.02 requires that all single-family lots have a minimum lot size of 2.3 acres with 100,000 square feet of contiguous upland area with a minimum of 250 feet of frontage on a Class 5 or better road. The proposed subdivision of the property consists of creating 3 lots. The proposed lots will consist of approximately 2.44 acres with 250 feet of frontage, 3.19 acres with 250 feet of frontage, and 22.4 acres with 209.9 feet of frontage, which requires relief from Section 3.02 since we are not satisfying the 250 feet for that particular lot. Mr. and Mrs. Sean Farrell are looking to purchase the subject property so that they can build their dream home on the 22-plus acre parcel and continue their residency in Merrimack. In order to execute the purchase of the property, the Farrells need to create the 2 lots on the front of the property and are thereby seeking a variance for the 3rd lot in the completion of the 3-lot subdivision of the property. Although the current proposal requires a variance to subdivide the subject property into 3 frontage lots, we think it is important for the board to know that the existing parcel could be subdivided into 5 residential lots, which would conform to the zoning regulations if somebody purchased the property and was interested in building a short public road onto the parcel. This information is shared as we believe it speaks to the reasonable and responsible development of the proposal that we have before you this evening. And I do have a conceptual plan that shows that development. The owner of the property, Brett Vaughn, had contemplated doing a development of that fashion, and then ultimately Mr. Farrell approached him with interest in the property and now is proposing just a 3-lot subdivision.
All right, so we read the 5 criteria?
You have it, yep.
Thanks.
Criteria number 1, granting the variance would not be contrary to the public interest because granting this variance would allow for the productive use of the existing property. This proposal is consistent with the surroundings as many of the lots along Wilson Hill Road possess closer to 100 feet of frontage with lot sizes ranging from 1.5 to 2.5 acres. Granting this variance would therefore not alter the essential character of the neighborhood or threaten the health, safety, or general welfare of the public. It is our belief that this proposal will have no negative impact to the general public. For these reasons, we believe this proposal would not be contrary to the public interest. We certainly believe that developing a 28-plus acre parcel into 3 lots while preserving large acreage would be in the public interest given other alternatives that could contemplate a more intense development.
Any questions on this? Okay, number 2, please.
Number 2, granting the variance would observe the spirit of the ordinance because we believe this proposal is reasonable and meets the spirit of the ordinance, especially when you contemplate the size of the parcel, being 28-plus acres, the size of the lots that are proposed, and the placement of the proposed building sites in relation to the surrounding lots. Section 3.02 of the Merrimack zoning ordinance requires that lots have a minimum frontage of 250 feet and a minimum of 2.3 acres and 100,000 square feet of contiguous upland area. We believe that the intent of this ordinance is to provide adequate separation and buffering between landowners and uses. For example, with a 2.3 acre lot, you would need to have 250 feet of frontage so that you have a reasonable geometry to provide for a building envelope and buffering to the abutting properties. When you have an irregular shaped parcel like the subject lot, we believe the frontage becomes less critical, especially when you can provide for large lots with significant separation from the proposed building site to the adjacent lots. In this case, we believe the proposed building site should be evaluated. For example, the building site on the proposed reduced frontage lot is located to the rear of the property and would provide significant buffering to the surrounding properties. We believe when you evaluate the project from this standpoint, the proposal is certainly consistent with its surroundings and in our opinion, meets the spirit of the ordinance. We therefore believe that granting the variance would observe the spirit of the ordinance.
Any questions? Number 3.
Sure. Number 3, granting the variance would do substantial justice because granting this variance would allow for the productive use of the land as well as allowing Mr. and Mrs. Farrell to build their dream home on a 22-plus acre parcel with lots of privacy and river frontage. The Farrells look forward to moving to this property, enjoying the passive recreation activities that the property and the surroundings offer. Granting this variance would have no impact on the general public as the proposal is consistent with its surroundings. The variance request is for a reduction in frontage from 250 feet to 209.9 feet, a reduction of 40.1 feet. Many of the lots along Wilson Hill Road possess closer to 100 feet of frontage, with lot sizes ranging from 1.5 to 2.5 acres. Granting this variance would therefore not alter the essential character of the neighborhood or threaten the health, safety, or general welfare of the public. Based on these points, we believe that this proposal will have no negative impact to the public. We certainly believe that developing the 28-plus acre parcel into 3 lots while preserving the large acreage would be in the public interest.
Any questions? Number 4.
Number 4, for the following reasons, the values of the surrounding properties will not be diminished. This proposal consists of subdividing a 28-plus acre parcel into 3 residential lots. The use is consistent with the zoning and the surroundings and will have no negative impacts on the surrounding properties. Since this proposal is consistent with the neighboring properties and for all of the reasons that I've previously stated, we do not believe that this proposal would have any negative impacts on the surrounding property values. We believe that this proposal may actually increase the surrounding property values as it will create a subdivision with large buffering between neighboring properties, will preserve a 22-plus acre lot along the river, and does not maximize the full development potential of the parcel.
Number 5.
Number 5, owing to the special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, number 1, no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property because the subject property is unique given its geometry and size. Granting this variance would allow for the productive use of the existing property. The zoning for the property is Residential 1, which has a minimum lot size of 100,000 square feet of contiguous upland area and 2.3 acres with 250 feet of frontage. It is our belief that the development of this 28-plus acre property into 3 residential lots is reasonable and fair when you contemplate the general public purpose of the ordinance provision and the specific application of that provision to the property. I'm still going. That's okay.
Sorry.
This proposal seeks a variance to permit a 22-plus acre lot with 209.9 feet of frontage, which is 40.1 feet short of the required 250 feet. The same parcel could be developed differently with a public road, as previously stated, into 5 lots. This development option would meet the ordinance but would result in significant land alteration and is not the desire of my client. It is our belief that the general public purpose of this ordinance is to provide adequate spacing and buffering between homes and to prevent overcrowding. The development of the subject parcel will provide more space and buffering between homes than alternative designs that could be done on the property, which is why we believe there is no fair and substantial relationship between the general public purpose of the ordinance provision and the specific application of the provision to the property. We believe this property does possess special conditions as it is unique in its geometry and size. Although this proposal requires a variance for frontage, we believe that the style of the development is consistent with its surroundings and would be supported by the general public.
Jillian, you know I've got a question on this.
'Cause we,
It flew out at me. How can we have two addresses that are exactly the same with two different lot numbers to it?
This is not 50 Wilson Hill Road. This is a different piece of property.
What number Wilson Hill Road is this then?
It doesn't have a number.
Doesn't have a number. It's
this is just Wilson Hill Road.
undeveloped.
Okay.
So how did it get assigned a number then?
It doesn't have one.
I just said Wilson. Sorry, we had another variance on Wilson Hill Road in
Yeah.
the past, so we just want to make sure it wasn't
The same one?
So we apologize for that.
Okay,
Um,
sure.
But any questions for the Mr. Farrell?
As long as it's not the same lot, I'm all set on that.
So I'm looking at the plans. So they're gonna the house. I take it they're gonna take the house in the back.
That would be
The
correct.
front, the one. Okay. So why the two? Why just not? Why build the two houses to get the other two houses to be?
In order to purchase the property for, I'm assuming, financial reasons, they need to create two outlots to sell
Income. Gotcha. That's. I kind of thought so. I just wanted to make sure. All right. And so basically, what we're looking at here is just the reduced frontage of those two lots.
It's a reduced frontage on one lot.
The one lot,
And it's
okay.
the 22 plus acre lot. The other two lots satisfy all of the requirements of the zoning.
Okay. Yeah, I got it. What's up?
I've got a question on the butters. I'm McGregor's and Jones, not the butters.
I'm not sure what we're looking at. For a
Well,
butter.
McGregor is just east of this lot. It looks like it abuts it. And Jones is just west of this lot.
Jones isn't living in town right now.
Well, it's dead that. For the property.
Right.
It appears as though they're shown as abutters on the plan.
I have there's a list of abutters here, and there are three listed. Robitel, Wood, and Grimes.
The file lists them as abutters, and they had notices from the file.
Okay.
Is there anybody? I'm going to open this up to public discussion. Is there anybody that would like to speak in favor of this variance? Is there anybody that'd like to speak against this variance? Come on down. Please sign in. Were you sworn in?
No,
Could you please
Yes,
swear to tell the truth, the whole truth, and the truth, so help you God?
I do.
Thank you very much.
I see the green lights on, so.
Yep, just state your name and let
My name
us.
is James Wood, I'm an abutter.
All right, would you push the button again, please, and make sure it's bright
Okay,
green?
it's bright green.
Yeah,
Yes.
there we go.
Okay, sorry. On a butter across the street. I only question, what is the issue now? We're gonna change our zoning so somebody can afford to move there? Is that what we're doing? So now we're gonna divide you have a 250-foot road frontage is the standard in Merrimack, from what I read. So we're gonna reduce his road frontage just so he can afford to buy the piece of property? That's my question. I don't know what is acceptable in Merrimack, so I'm just asking that question because I thought that was the standard we were using. So, I have to. Anybody have an answer?
I mean, what he's asking for, yes, is a variance to be able to subdivide the land, and by the sound of it, it is to be
Before he buys it,
be able to, you know.
so he can afford it.
I didn't know if he's. Is he
Okay,
purchasing
well, I'm
it?
just saying that.
Hold on a second. don't interrupt me.
I'm sorry.
I didn't interrupt you.
I'm
Okay,
sorry.
all right. I don't know if he has or has not purchased it yet. Obviously wants to be able to get the variance. If he hasn't purchased it, wants to make sure that he gets the variance so that he can do it. It does sound by my questioning that yes, he is looking to do that so that it does create a source of income, allowing him to buy the property based upon the question that I asked him. So to answer your question, yes, it sounds like he is looking to subdivide it to be able to have the income necessary to acquire the land in the first place. So yes, based upon the question that I asked earlier, unless there was something I missed.
Okay, well, I just tried to figure that out myself too. So I know that property pretty well. It's right across the street from my house.
Sure.
And I hear that it is a unique piece of property. Almost all Wilson Hill is unique. If you've been traveling up and down that road, most of the property is almost unbuildable on. So there is some land where you can build, but it takes quite an effort to put any kind of house on that. And a lot of land across from where we're at is raw land, like he's going to buy. It's kind of, you can't even build on it because wet areas. We have a drain that comes off the hill and it runs out front of my house, sweeps across, goes underneath the road, and provides a wet area about 100 feet around, just on the other side of the road. And ever since they built the road on that piece of property, that water backs up, and my water backs up on my side of them. Mm-hmm. So anything we're going to build on the other side has a great deal to do with water runoff off of the hill. So I am concerned about that.
Mm-hmm.
I mean, that's just something, whenever we're going to start splitting up, building houses, you're talking about building in areas where right now, if you go out there and look at the site, I know this isn't your thing, but when you're going to give somebody a variance.
We all go out and look at the sites.
Okay,
when we do this.
I didn't know if you'd been out there and
Yeah.
looked at this land.
Mm-hmm.
It is very tough to build out there. I mean, don't care if anybody develops it, but I'd like to have some type of standard, I guess, that if that's what we're going to use, 250 foot. I know it's deep. I've been walked back there before down to the river. It's a nice piece of property. But that was my concern, was if, I guess 209 feet, 250 feet, I thought we'd just go by the standard because out there people are starting to develop out there, and it's going to turn more into a subdivision than it is into a rural area that I've lived out there for 16 years, where it's been country. I don't want it to turn into another subdivision in downtown Merrimack. I mean, that's one of the concerns I've got, because when you start developing it and you start making 209, next somebody will say 180 feet. And, I mean, they're starting the slope now, going down it, a variance like that. You're starting to give people the leeway now. They're going to subdivide this, and they're going to put 2 more houses out there. Now we're changing the whole nature of that area out there in Merrimack. And I think it will eventually hurt houses out there, because people that move out there usually want to be out where there is nobody, where you have some space isolation between houses. I mean, that's just a feeling I've got, because the people that lived out there, I've lived out there 16 years now, I chose that area specifically because it was isolated and we had space. I understand that people that own property have the right to develop it. I'm not going to debate that at all. That's America. But I would like to at least to take into account that if we have a 250-foot road frontage, then that's what we should be using to develop these properties, so we actually have spacing on everything.
No, I agree with you 100% on that. As far as, and that's why that is in there, and that's why he's here today. Whether or not we decide to move forward, that's something that we'll discuss and definitely take into consideration. I guess I could say that obviously if that area is going to be developed, if there are homes going to be put in there, drainage issues would have to be addressed, and that might improve the situation of drainage overall for the entire road, especially if the road does become more developed. The town would need to address that road in and of itself and take care of drainage issues. So, but I know that's not what you're here for today, and I know, but I understand where you're coming from on that.
Okay, thank you. I just thank you very much for your time.
I appreciate it. Thank you.
Thanks.
Is there anybody else that would like to speak against this variance? Okay, is there any final questions for Mr. Farrell? From the board? Nobody? Tony? All set? All right, I'm going to close the public hearing and
That's a long driveway.
open up the discussion for the board.
If I could, Mr. Chairman,
Sorry, yes?
may I answer some of the questions that the abutter has raised?
All right, I'll reopen the public hearing.
I appreciate that. Thank
Yep.
you. Just to speak about the application, the purpose of our application and the points that we've addressed is not to represent a financial burden and have that be the basis. The purpose of our application is to speak to what is the reason for 250 feet of frontage. And typically it's for a 2-acre or 2.3 acre lot and 250 feet of frontage, and houses are going to be placed in relatively the same proximity off the road. And at that point, it would be to allow for adequate buffering between the lots. We're asking for relief because we believe, given the geometry of the parcel and where we're proposing to build on the property, that we're actually providing more buffer than what would be achieved if this lot did have 250 feet of frontage. So we're requesting relief based on the geometry of the parcel. And we're pointing out that there are other ways that the property could be developed into a higher density. Just to speak to the terrain of the property, because there's some drainage concerns that the abutter raised, all of the property drains and is sloped away from Wilson Hill Road. None of the property drains towards Wilson Hill Road. There is a wetland, which we have depicted on our plan that runs through here. That does come off of, there's a drainage culvert that comes under Wilson Hill Road at that location. So any runoff from the property would ultimately drain in that direction and ultimately be conveyed towards the river to the back. That would certainly be something that we would address during the planning board process if we're able to get to that point. Speaking to the lots themselves, we actually have dug test pits on all of the lots. We performed on-site survey and topography, and we are certainly testifying that there is adequate room, space, and soils to support 3 lots in the proposal that we are presenting this evening. In regards to a rural issue, I think that this proposal actually maintains rural character and rural settings. I mean, we have a 22-plus acre parcel that will be maintained. You will not see that property at all from Wilson Hill Road as far as any the development of the home or so on. The other 2 lots do meet your ordinance. So I just wanted to clarify, certainly some of the concerns that were raised, and I'd be happy to try to answer any questions that you may have relative to those.
I actually do have a question. So if you weren't going to do 3 homes, you wouldn't need to be here, right? Because, I mean, it looks like you have enough to be able to, I mean, the total frontage out of all of it is over 500 feet.
Right. The total frontage is 709.9. So the original proposal for this property from the landowner, Brett Vaughn, was to do a 5-lot subdivision. Mr. Farrell approached Mr. Vaughn and showed that he had interest in the property. So the arrangement with this project is that the Farrells would maintain the back lot, and Mr. Vaughn will retain the 2 frontage lots, and he won't go forward with a larger subdivision of the property. So that's why we're proposing 3 lots. It's a 3-lot subdivision. This proposal doesn't work if it's 2 lots.
Okay. Any other questions from the board?
No, I just wanted to say, if possible, if this does go through and before you start the work on it, if you could probably just speak with the abutter first and see if you two can work some sort of an agreement out without, with being neighborly type of thing. Would that be agreeable to you, both of you?
We can speak tonight.
But that's what I would suggest, and it might solve a lot of problems before and after.
Thank you.
Any other questions, comments? All right, now I'm going to close the public hearing. Discussion from the board?
I'm all set.
Yes, ma'am.
This makes a lot more sense density-wise than other options that might be there, and I think it does go towards retaining the rural atmosphere that's out in that area, because it is rural. Both of those houses are, at least two of the houses are set back beyond where, I think it's the McGregor's house is kind of down in there's a field there that's kind of stuck back there.
The McGregor's are actually on the other side in the woods.
Over that hill,
Mhm.
big rock that's there.
Okay.
We're on the other side of the big
Okay.
rock.
Across from the Grimes'.
Yeah, okay, but this maintains a much more rural atmosphere out there than other options that we might have had.
Technically, they'll only see two houses,
Right.
not three.
Right.
And, yeah, I agree with you, because I could easily see somebody trying to divide that into a 6 or 7 family, or 6 or 7, a lot, space. I agree. It does preserve some of the open space from that perspective. If there's no other discussion? Rich, you've been kind of quiet.
I can reiterate what Lynn just said, but I wish to state concurrence.
Excellent. Excellent. All right, can I have a motion, please?
Well, if you don't mind, I haven't done one in quite a while.
By all means.
Sean Farrell, petitioner, and Brett W. Vaughn, revocable trust, the owner, requesting a variance. I make a motion.
To approve. Motion to approve.
I haven't done it for so long, I've forgotten how to
All
do
right,
it.
let's do it.
I move that we grant the variance for Sean Farrell, petitioner, and Brett W. Vaughn, revocable trust, the owner, a variance under section 3.02 of the zoning ordinance to permit a subdivision with a lot containing 209.90 feet of frontage, whereas 250 feet are required. This parcel is located on Wilson Hill Road in the R1 Residential and the Aquifer Conservation Districts, tax map 4A, lot 004, case number 2015-43.
Can I have a second?
Second.
All in favor, say aye.
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 All opposed? 4-1. And that's where we're at. You're all set. Next petition, Mark Rivet of 427 Daniel Webster Highway LLC, petitioner owner, variance under section 2.02.13E 4AB of the zoning ordinance to permit the construction of an additional 24 by 32 foot two-car garage 2.3 feet from the side property line, whereas 15 feet is required. The parcel is located at 427 Daniel Webster Highway in the C2 General Commercial and Aquifer Conservation Elderly and Town Center Overlay Districts, tax map 5D-4 lot 076, case number 2015-44. Mr. Farrell, what a surprise. How you doing?
It's
Welcome
Mr.
back.
Brannon. I'm
Welcome back. Long time no see.
Good evening, Mr. Chairman, members of the board again. For the record, Chad Brannon with Fieldstone Land Consultants. I'll be representing Mr. Rivet this evening, who is sitting to my left. And we are before you tonight requesting a variance under Section 2.02.13E4B of the Merrimack zoning ordinance to permit the expansion of a structure on the subject property. The board may recall that we were before you back on March 25th of this year seeking relief to construct a 24 by 36 garage 2.3 feet off the east boundary of the parcel, also case 2015-09. This structure was proposed to consist of a 3-car garage on the first level to service the duplex that was proposed. The second floor over the garage was to be storage, and then there was a drive-under component which was going to be accessed from the funeral home lot, and that was going to be a full drive-under. Unfortunately, during the design stages of the garage, my client found that the company designing the precast deck had misrepresented the height requirements for the decking or the floor, which impacted the feasibility of the drive-under option. In an effort to still address the storage need, my client chose to enlarge the 24 by 36 garage by adding a 24 by 32 addition off the south side. Although the addition will provide for less storage than the original drive-under option, it will be capable of storing 2 vehicles and addressing a storage need. When we presented this change to the Community Development Office, it was their opinion that this change would need to go back before this board for relief under Section 2.0213E4B, as the proposed addition will also be constructed 2.3 feet off the eastern boundary of the subject property where a 15-foot setback is required.
So, because I've seen this a couple times, by the way, it looks a lot better than it did. Thank you. And I've seen this property redevelop, and we've seen this a couple times. So, the front garage, I'm sorry, so you were the people you bought the flooring from? I didn't get that part.
I think I can explain it a little better here. So initially, part of the previous proposal just consisted of this 3-car garage for the duplex. It was going to have a second story for storage, and then there was a drive-under that was going to be accessed from the funeral home. Because of the difference in topography and the elevations, it was working, but the margins that it was working were relatively small. When the company that was designing the precast concrete deck initially gave dimensions, everything worked fine for garage doors on the drive-under.
You're talking the floor, the precast.
That bridge panels.
The floor?
The bridge panels,
Okay.
those concrete floor to hold the cars above.
All right.
Once we got the approvals and went into the design stage, what ultimately was revealed is that the depth of that floor required, not only did we have to contemplate the depth of the floor, but they were also requiring a header underneath the decking, and that was not initially discussed. And ultimately, the additional 18 inches or so that was required for the header, deemed the drive-under option not possible.
Well, it would have made the approach from the duplex side very steep.
It was,
the grade would have been.
Or it would have drove the building up so high that it would have looked horrible.
Okay. All right.
It would have been about, was it 6 feet out of the ground?
It was
for the foundation height, not anything wood above it.
And this is something that's been. This is like a totally unexpected. This is
certainly.
That's why we're here today.
Yeah. Okay. Exactly.
I spent money on those bridge panels that I don't have anymore. It was not expected.
Okay. If you'd like to do the 5 points, that'd be great.
Sure.
I'm sorry. Do you have a question? I apologize. We'll address it.
Go through the 5 points? Okay. Number 1, granting the variance would not be contrary to the public interest because the redevelopment of this parcel has consisted of raising the existing non-conforming residential structure and shed and the construction of a new residential duplex in conformance with the local zoning setbacks. The new development has provided for site improvements and amenities such as paved access and parking, as well as garage space and indoor storage for the future tenants. The garage and storage space for the new duplex is provided for in the new three-car garage located on the east corner of the parcel. The garage structure was originally positioned to provide storage and access to the lower level from the adjacent business, being the funeral home. The final design of the original structure yielded the drive-under option and associated storage space unfeasible, thereby requiring the expansion of the garage as proposed. The proposed expansion takes advantage of the existing topography and existing features, which will permit access from Lot 5D 4-77. The design of the site will not create any health or safety problems and will provide additional housing for the community while addressing a storage need for my client. This project will substantially improve the aesthetics of the subject parcel and the surroundings. The uses proposed are permitted in the underlying zoning and will be consistent with the surroundings. Since this proposal will provide this while resulting in no negative impacts to the public, we believe granting the variance would not be contrary to the public interest.
Any questions? Okay.
Number 2, granting the variance would observe the spirit of the ordinance because this project consists of redeveloping an existing parcel in town, which will substantially improve the aesthetics of the subject property and the surroundings. The use proposed for the property is permitted in the underlying zoning and will be consistent with the surroundings. The new garage will provide needed storage for my client. The site plan demonstrates that there is adequate space on the subject property to support this redevelopment. Section 2.02134B of the Merrimack zoning ordinance requires that a 15-foot side yard setback be provided. We believe that the intent of this ordinance is to provide adequate separation and buffering between landowners and uses. Since the proposed structure will be shared between properties for storage purposes, there should be no requirement for separation or buffering. Since this proposal will provide all of these all of the all the previous statements and will result in no negative impacts to the public, we believe that granting the variance would observe the spirit of the ordinance.
Questions? All right, number 3.
Number 3, granting the variance would do substantial justice because granting this variance would allow for the productive use of an existing lot and provide needed storage for a long-standing business. As stated before, this variance is required in order to situate the garage appropriately with the existing site improvements and to permit access from the funeral home property as shown on the site plan. The use proposed are permitted in the underlying zoning and will be consistent with the surroundings. This project will provide quality housing for the community and address a storage need for the adjacent funeral home. This project will also increase the local tax base. Granting this variance would do substantial justice because it would allow for the productive use of the property while providing reasonable growth in the community.
Any questions? Number 4.
For the following reasons, the values of the surrounding properties will not be diminished. This project has consisted of improving the existing conditions of the subject property. The development of this property has improved the aesthetics of the parcel, which should have a positive impact on the surroundings. The uses proposed are permitted in the underlying zoning and are consistent with the surroundings. It has also been our experience that new construction and development will actually increase the value of surrounding properties. As a result, we would expect this project to have positive impacts on the surrounding properties.
Questions? Number 5.
Owing to the special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, number 1, no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property because Section 2.02134B of the Merrimack zoning ordinance requires that a 15-foot side yard setback be provided. We believe that the intent of this ordinance is to provide adequate separation and buffering between landowners and uses. Since the proposed structure will be shared between properties for storage purposes, there should be no requirement for separation or buffering in this application. In fact, the location of the garage is required to take advantage of existing topography and site improvements for access to the structure from the adjacent parcel as depicted on the site plan. The location of the garage will have no negative impact on the general public. Based on the above, we do not believe that a fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property. Number 2, the proposed use is a reasonable one because this project consists of redeveloping an existing property in town, which will substantially improve the aesthetics of the subject parcel and the surroundings. The use proposed for the property is permitted in the underlying zoning and will be consistent with the surroundings. The new garage will be shared between the subject parcel and the adjacent funeral home and has therefore been situated to best accommodate the existing features for access. The site plan demonstrates that there is adequate space on the subject property to support this redevelopment. Since the proposal will provide the above and will result in no negative impacts to the public, we believe that the proposed use is reasonable.
Any questions?
No.
Do you feel that A has been satisfied?
Yes.
Yes.
You don't need to read B.
Thank you.
Okay. Are there any other questions for Mr. Brannon or Mr. Rivet?
I just have a comment, and that's that of all the cases that we've done in the past, I remember this one the most vividly because it's the 429 DW Highway LLC on 427 DW Highway.
Right, yeah.
And so, like, when I looked at it, I'm like, oh, yeah, I remember that.
I think it's been ironed out to
Oh, really?
correct, yeah, I think it's been corrected all the way down now.
So you're seeking a variance basically for your own property because you have the property right next door, right? Got it. Just
Yes.
yeah, politics, right?
Yep.
All right. Yes. I'm sorry. You did have something to say before earlier. I apologize.
You had a variance prior to this for what you were actually proposing to do, and so you're back before us to get a variance for the expansion forward of that building, correct?
That is correct.
Yes.
Okay. Question 2, is there going to be an easement between those two properties for access?
There would be an easement. It would either be an easement or something stipulated in the deed that somebody has rights to access and.
Okay, because
Yeah, because they're going
You-
over that prop.
you own both of them right now, but you may not in the future.
Correct. Yeah.
So there will be something that
That's correct.
establishes the rights. Okay.
Any other questions for gentlemen before us?
No, it's just nice to see you in this environment instead of your environment.
I will second that.
Is there anybody that'd like to speak for? I'll open this up to the public. Is there anybody that would like to speak for this petition? Is there anybody like to speak against this petition? Okay. Unless there's any other questions of the gentleman, I'm going to close the public side of it. Tony, all set?
I'm all set.
All right. I'm going to close the public hearing and open it up to discussion for the board. Any questions? Thoughts, concerns, motions?
You gonna do it?
Why not? On second thought. To make a motion to grant, I almost blew it, grant the petition for Mark Rivers, a variance under section 202.13E 4B of the zoning ordinance to permit the construction of an additional 24 by 32 two-car garage, 2.3 feet from side property line, whereas 15 feet is required. The parcel is located at 427 DW Highway in the C2 General Commercial and Aquifer Conservation, Elderly and Town Center Overlay District. Well, that's a mouthful. A tax map 5D4 Lot 072, case 2015. Sorry about that.
Sorry.
Lot, no, you're right. 076, case 2015-44.
Second.
All in favor?
Aye.
Opposed? 5-0. It's great to see you again. Have a great evening, gentlemen.
Thank you very much.
And have a good Thanksgiving.
And have a great garage.
All right. You've been patient. We appreciate that, believe me.
And you were able to get up and stretch your legs, too.
Thomas L. Worst, petitioner owner, variance under section 3.05 of the zoning ordinance to permit the placement of solar panels approximately 3 feet from the 3 feet front the side property line, whereas 15 feet, it doesn't say that. 15 feet is required and 30 feet from the rear property line, whereas 40 feet is required. The parcel is located at 3 Laurel Street in the R Residential and Aquifer Conservation District's tax map 4C, lot 139, case number 2015-45. If you could please sign in and state your name.
Hi, I'm Tom Worst.
Tom, it's great to see you. Thank you for your patience this evening. If you could give us just a quick elevator 5-minute pitch on why you're here, and then we'll get into the 5 points and go from there.
Okay.
30-second pitch, not 5.
30 seconds. Yeah. Sorry.
I think that what you just read pretty much summarizes it. I have a piece of property where on the northern side of the parcel, there's ledge that's exposed and it slopes up to the neighbor's property. And in order to be able for it to blend better into the environment, and also so that it's not over top of arable land where I want to have a garden and etc. I like to put it up as far against that ledge as I can in order to get it out of the way.
All right. Well, if you could read your 5 points.
Sure.
Please.
So number 1, granting the variance would not be contrary to the public interest, as there would be no negative impact on the general public as a result of granting this variance. In fact, there will be positive benefits for the public. The purpose of installing these solar panels is to generate electricity for use by the residents at this address. This will reduce demand in the power grid, particularly during daytime peak load periods, reducing greenhouse gas production, our dependence on foreign energy sources, and the need for new power projects such as Northern Pass and the proposed natural gas pipeline through southern New Hampshire. Locating the solar panels as proposed will help maximize electricity production by keeping the panels in sunlight later into the afternoon. Solar panels are not a building but a piece of equipment. They will reduce use of the affected area. The intention of setbacks is to provide a buffer between owners and uses. Locating the solar panel array as proposed will improve the effectiveness of the buffer at this point, since it will limit activities in this area. The plan is also to mount the panels at a lower angle than is typical for a ground mount array, close to the slope of the land in that area, so that it better blends into the environment.
So, my first question, and maybe public interest. Actually, you know what? I'm gonna hold to the. I'll let you continue. Does anyone else have any other questions on number 1? Okay.
Okay. Number 2, the spirit of the ordinance is observed because the proposed use is in keeping with the underlying zoning. Solar panels are not a building but a piece of equipment. They will reduce use of the affected area. The intention of setbacks is to provide a buffer between owners and uses. Locating the solar panel array as proposed will improve the effectiveness of the buffer at this point, since it will limit activities in this area. At the rear of the property, there is an effective screen of coniferous trees in addition to elevated land between the subject property and the abutters, which effectively obstruct the view of the subject property and proposed solar array. In addition, a hedge of forsythia and mistletoe has been planted along the rear property line, which should totally block view of the proposed solar project from the rear abutters in a few years.
Anybody have any questions?
No.
Number 3?
Okay. Granting the variance would do substantial justice because the proposed use is in keeping with the underlying zoning. The proposed location for the solar panels is located over exposed ledge, which provides a stable foundation for the panels, will require little or no maintenance once the panels are in place, and makes use of a portion of the property that can be used for little else. If we are not permitted to locate the panels as proposed, they will first off be away from the slope at the edge of the property so that the array will be farther off the ground, reducing the aesthetics of the installation. The array will be much more visible from the adjoining property and the street. Secondly, it will be in shade earlier in the afternoon, reducing the energy production of the array. Thirdly, end up farther from the ultimate connection point to the home, adding to the cost of the project. And thirdly, end up partly over arable land, which we plan on using for a vegetable garden.
Number 3, any questions?
No, I'll wait also.
Okay, number 4, please.
Okay. For the following reasons, the values of surrounding properties will not be diminished. First off, the proposed use is in keeping with the underlying zoning. And secondly, as planned, the panels will be mounted following the contours of the land, reducing visibility and improving the aesthetics of the project from adjacent properties and the street.
Any questions on number 4? Okay, number 5.
Okay. Unnecessary hardship. A, owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because, 1, no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property because the intention of setbacks is to provide a buffer between owners and uses. In this case, there is, first off, a hill between the subject property and the adjacent property at the side boundary, with the crest of the hill essentially at the property line. And secondly, a hill and or berm between the subject property and adjacent properties to the rear, with a row of coniferous trees along the abutter side of the property line that pretty much completely block view of the subject property and proposed solar array. In addition, a row of forsythia bushes and mistletoe bushes have been planted along the rear property line, which will grow into a tall hedge in a few years. By locating the proposed solar panels close to the property line and at a slope close to that of the underlying grade, the proposed project will be less visible to the adjacent and other properties than if it were located outside the side and rear setbacks. Also, by having the solar panels located close to the side property line, there will be likely less activity near the property line, enhancing the privacy of that adjacent property's backyard.
And you can go on to number 2.
Okay, and number 2, the proposed use is a reasonable one because the proposed use is in keeping with the underlying zoning. The intention of setbacks is to provide a buffer between owners and uses. The proposed solar array is not a building, it is a piece of equipment. It will reduce use of the affected area. Locating the solar panel array as proposed will improve the effectiveness of the buffer at this point, since it will limit activities in this area rather than increase them. Due to the topology of the land present, this proposal improves privacy of the adjacent property on the northeast side. Also, due to the topology of the land at the rear of the subject property and adjacent properties, plus existing coniferous and deciduous trees, the solar panels will be hardly visible, if at all. With the addition of shrubs planted by applicant/owner along the rear property line, any visibility will decrease and privacy will increase with time.
Does anybody feel that was...
There's a
Oh, I'm sorry, there was another section I paused. Go ahead.
Locating the solar panels as planned improves the aesthetics of the project as compared to a conventional installation at a steeper angle outside the side setback. Locating the solar panels as planned increases afternoon sun exposure and therefore energy production. The exposed ledge in this area provides a good foundation for the solar panels and puts a portion of the subject property that would otherwise serve little purpose to good use. Moving the solar panels out of the side setback would result in the loss of use of arable land that will otherwise provide food for the residents. Additionally, these solar panels will reduce demand on the power grid, especially during peak load periods, reducing greenhouse gas production, our dependence on foreign energy sources, and the need for new power projects such as Northern Pass and the proposed natural gas pipeline through southern New Hampshire.
Everybody feel that was satisfied, Harsha?
Yes.
Any questions for the applicant?
Yes, I'm
Fran?
serious. I have 2 of them for you.
Sure.
What are the size of these panels?
Each panel is, I believe, about 40 inches by 66 inches. The overall array is 17 feet by 31 and a half feet.
All right. And on this picture here,
Mm-hmm.
have you already started to install the panels?
No.
This gray one, it looks like there's an electrical cord coming out of it.
Let me see. Mind that? Point it out. That's a piece of pipe. It's a 2-inch pipe that used to be servicing. What you see is a piece of plastic pipe that used to service the sump pump from the home when we had regraded the property, and it used to go up and down, and so they had a long piece of pipe that went from the house out back and over.
All right.
So that pipe now is sitting back in front of the berm.
Why on the ground? Why not? I mean, a lot of people, I'm starting to see more and more solar panels. Most of them are putting it on the roof. Seems like you put it on the ground, it's going to get covered with 2 or 3 feet of snow, as we all know is coming. So why not on the roof, and why? Because if it was on the roof, I don't think you'd have to be sitting here asking for
Right.
a variance.
And the reason we're not putting it on the roof is because, number one, the roof is, the shingles are fairly old, and it would need to be re-roofed, number one. Number two, we already are thinking in terms of putting some dormers on the front to improve the ventilation of those particular rooms upstairs. The one room right now, the only window in is, I think, about like that. And really, we wanted to get some better ventilation going in there, so the dormers were what we were planning to do. And once you have dormers, it really makes it inappropriate for solar panels.
Yes. Okay. Any other questions? All right, I'll open this up to the public. Is there anybody that'd like to speak in favor? Is there anybody that'd like to speak against? Okay. Were you sworn in earlier?
Yes.
Okay.
My name is Michael Phillips. I live at 1 Laurel Street.
Okay.
I just have a few concerns about the placement of the solar array close to the property line.
So where are you in relation to the?
So I'm next to him.
Okay.
So the ledge that he talks about, that is right on my property line.
Okay.
Okay, so one concern that I have would be the possible negative effect of my property value. If, due to a structure or the solar panels themselves being too close to the property. Another concern I have would be the potential health hazards that solar panels give off, especially the inverters, like electromagnetic fields or electromagnetic radiation.
Okay.
And lastly, a concern I have would be for my child. I have one child, and when she starts walking and running around the yard, if she gets too close to that property line, I'm afraid that she may fall or, potentially like hit her head on the corner of a solar panel, or possibly even get an electric shock.
Okay.
So
now, okay. No, those are valid concerns. Okay. Questions or thoughts? Let's, if you want to step back, we can,
Thank
get kind of some clarification hopefully for you on that. Sorry, go ahead.
I was just going to ask if Mr. Worst has any information as to any, I don't want to say radiation, but any health concerns from these solar panels.
I know of nothing that's been substantiated. I've heard of people that are concerned about electromagnetic radiation. And like I said, I've heard of no studies that have been done that have substantiated any claims. And the fact that, I'm going to be putting the solar panels up one way or the other. I don't think it's going to make any difference in terms of any potential exposure to EMF, whether it's 15 feet in from the property line or not.
So if you don't get approved,
I'm putting the panels up on a ground mount array. I'll just move them out, and they'll be more visible and at a steeper angle. And
so the where you're putting them though, in regards to this gentleman's property line, is there, you said you planted mistletoe bushes, or? you're
That
planting
was in the
bushes?
rear. I'm certainly willing to plant a forsythia hedge, or we went out and we talked a little bit about possibly putting a fence up there, or I could tip the solar panels up on a higher angle if that's preferable, so there aren't any corners, within.
That's what I was going to suggest. What a fence should take care of something like that, shouldn't it?
Is that something that, well, I guess, that would be something the two of you'd have to work out as neighbors, but
Right.
It's not something we're here to address tonight, but.
If you're afraid that your daughter, when she starts walking, might run over to the property and trip and hit her head or something, but if there was some sort of fence there, even if, right now, a 3-foot fence would take care of it.
As far as the, okay. Any other questions? Thoughts?
The only thought that I have is that I'm sitting here trying to research it while we discuss this, and there are good and bad ways to install solar panels from what I'm seeing, and it is possible to have radiation in some cases emitted depending on how it's installed. There are ways of mitigating that. That's neither here nor there for the zoning board, but I definitely, when you said that earlier about the radiation, I thought, I didn't even know that's even possible. So that's an interesting side note. But like I said, if I were to start asking questions on what type of technology you're using and what type of inverters you're using, then we're kind of leaving the zoning board at that point. So it's, I guess it's one of those things where there is a potential for unpleasant side effects of having solar panels. So there is some reality to that statement.
Okay.
Just out of curiosity, are you having them installed professionally, or are you putting them up yourself?
This is done with an organization called HOORAY, the Hillsborough Area Renewable Energy Initiative. They've been doing what they call energy raisers, similar to the old, barn raisers. Community gets together and puts stuff up. So we have a member of the group that's an electrician, another member of the group that's actually in the business of putting up solar panels, and we all work together and help each other out.
Any other questions, concerns?
I don't see the hardship that's involved here, where it's possible to put the panels up such that they're not encroaching into the setback. And then the question arises is, and this is for Jillian, if this is this considered a structure?
It is under section 2.02.A.8 of the zoning ordinance, which pertains to solar panels.
Okay. But I don't see that there's a hardship here. I can see preference for installing them one way or another, but I don't see that there's a hardship to getting into the setback.
Any other questions, concerns?
I guess my only question is it says approximately 3 feet. What does approximately mean in this case?
It'll be at least 3 feet from
okay.
the setback. As I got in, when I wrote that, I hadn't actually put up anything. Right now, I have a wooden frame that's set up that's approximately the size of the proposed array, and I haven't measured it off accurately, but I think I'm at least 4 feet from the property line at the closest point. It's actually angling a bit away from the property line, so that by the time you get to the far end, it's 15 feet, and it might just be encroaching a few feet into the back setback.
Okay, so 3 feet at minimum distance.
Right.
Okay, thank you.
Any other questions, concerns? All right, I'm going to close the public hearing. Discussion on the board? I'll start, I'll say, Lynn, I do see what you're saying, and I'm in agreement to that.
I am aware of the organization that is doing this. I'm very familiar with them. And I think that they're doing some great work, and I commend you for putting these up, but I want you within the setback.
Any other discussion, comments, questions? Do I have a motion?
I will make a motion to deny the request for variance by Tom Worst under section 3.05 of the zoning ordinance to permit the placement of solar panels approximately 3 feet from the side property line, whereas 15 feet is required, and 30 feet from the rear property line, whereas 40 feet is required. Parcels located at 3 Laurel Street in the R Residential and Aquifer Conservation Districts, tax map 4C, lot 139, case 2015-45.
I'll second that.
Just the only thing that I would add to that is that it doesn't meet the criteria for.
Oh, you have to give your reason for
Yes,
the.
you do have to give
I
your
didn't.
Just
Reading this again.
What he said
doesn't.
doesn't meet the criteria based on
Okay.
hardship.
All in favor of denial, say aye.
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 All opposed? 5-0. Motion's denied.
And I'm going to get in trouble with my sister. She's part of that group.
I don't even know where I'm at anymore. Where's my table of contents thingy? Who's got table of contents? New items. Anybody have anything new they'd like to discuss?
I would like to introduce Robert Price to the board. I didn't get a chance to at the beginning of the meeting, but he's our new assistant planner, and we're certainly glad he's here, and he'll see his face around this board too.
You picked a doozy of your first meeting, I'll tell you that right now.
So how is it you guys are getting people and we're not? How's that working?
You're not getting anyone?
Do we have an open spot?
Yes.
Oh,
the
yeah.
Alternate.
Alternate.
Kidding?
Huh.
Actually,
I'm just waiting for people to apply.
All right.
Well,
Welcome.
welcome.
And we have the minutes for Wednesday, October 20th, unless there's anything else, Julie?
I would just like to thank Patrick for taking over the chairman slot last month and this month for me.
My pleasure. Glad you're back. I'm glad you're okay.
Oh, thank you.
It is. We're glad we got you to keep Tony in line. All right.
Well, that's why I sat between the two of you.
So the minutes for Wednesday, October 28th, 2015. Any questions, concerns, editorials?
I move we approve them as printed.
Second.
Seconded. Any other discussion? All in favor of approving the minutes as is, say aye.
Aye.
abstain.
Okay.
Well, if he abstains, I abstain.
3 approval, so 3-0-2. And
Motion to adjourn?
do I have a second? Seconded. All in favor?
Aye.
Rich seconded the motion to adjourn. Thank you very much. Have a great Thanksgiving, everybody.
Yes, you too.
And enjoy your holiday season. Have a good night.